As we all emerge from a pandemic, the world has undergone a profound shift. On one hand, there are talks of wars and great games of politics. On the other hand, there are discussions of recessions and supply chain shocks. In this course, we zoom to one area of global economy: international investment. To some, foreign investment, or the FDI, is tantamount to development and growth. Let's call it element number one. Even though it is not a recent creation, the FDI has proliferated greatly since the end of the Cold War. The states needed international expertise and capital for their economies. The multinational enterprises competed fiercely for access to new sources of raw materials and markets, and the investment exporting states sought minimum safeguards in a world of different legal regimes. This, together, make up the international investment law.
Yet, like other legal regimes, it has developed cracks. Let's call it element number 2. Indigenous communities saw their localities privatized. The youth saw themselves edged out. The climate activists saw multinational enterprises taking refuge behind these treaties. In some countries, governments fell, while in others, populists promising protectionism arose. Manifest in these protests were concerns about loss, regulatory power of the state, inequitable sharing of wealth, and harm to the environment. Put these two elements together, an international investment regime mirrors the challenges of our times. Whether one supports it, wants to reform it, or unbuild it, one is compelled to engage with it.
Today, with more than 2,500 bilateral investment treaties and hundreds of arbitral awards running into millions of dollars, international investment law is here to stay. In this course, we will deep dive into the details of how did this regime come about? What is its history? What are the standards of treatment that investors are entitled to? How did these standards evolve? What are their doctrines? What has been their criticisms? At what stage do these matters go to the tribunals? How are these tribunals composed? And what are their procedures?
We will also discuss the European initiative regarding multilateral dispute settlement system that hopes to move away from the private model towards a public model. And we will take a look at the strategy of Denmark in its pursuit of foreign investment and the recent screening law enacted last year. This course is about exploring the international investment regime as it stands today, alongside the debates of private versus public, the role of sustainability, and the scope of regulatory powers of the state. My name is Hersh Sewak. I am a PhD student here at the Faculty of Law.
And I am Joanna Lam, Professor MSO of International Economic Law. Together, we invite you to join us next semester for the course on International Investment Law
and
Sustainability.